Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice to come here and deliver a lecture on the topic of their choice. Today we have with us Advocate Aayush Kedia. Advocate Aayush has pursued his BCom along with his chartered accountancy. Advocate Aayush has completed his LLB from OP Jindal Global Law College, Delhi in the year 2022. He also holds a diploma in forensic science from Nalsar in 2023. Advocate Aayush practices in white collar crimes and commercial disputes pan India. Today he is going to speak on Bail under Prevention of Money Laundering Act 2002. So without wasting further time, I would request Advocate Aayush to commence with his lecture. Thank you.
Thank you to Hammurabi Tablets for giving me the opportunity of speaking on a topic which is very rampant in India today, and according to me something which is a topic which most of us as lawyers and also citizens of India must be aware about. That is the question of bail under the Prevention of Money Laundering Act of 2002. Now, what is the Prevention of Money Laundering Act of 2002? When the bill was introduced and when the law came into place, the act of money laundering and prevention of the same was of course important, since money laundering today is one of the most important and also the largest crimes that exist in India today. Each and every person who is, be it a small businessman or a large business owner or even a corporate, somewhere or the other is either a victim to money laundering or possibly an accused to money laundering. Now, before we go into understanding what the provisions of bail are with respect to the law, let us give a short understanding of what money laundering even means. Now, the Prevention of Money Laundering Act, White Section 3, gives a fairly comprehensive and broad understanding of what money laundering really is. It covers money laundering in 6 different steps and stages. However, in order to simplify money laundering, I would say, is that first there is a crime that gets committed which generates a certain kind of offensive money, you can say, which is also known as the proceeds of crime under the language of the PMLA. The word proceeds of crime is defined under Section 2, subsection 1, clause U of the Prevention of Money Laundering Act. Now, money laundering per se is the laundering of this money, which is the proceeds of crime. So therefore, let us take a very simple example at this juncture. There is a person who has stolen a sum of rupees 5 crores from Mr. A. The person who stolen is Mr. B. He has stolen this by hacking into the bank account of Mr. A or stealing the money through a wire transaction from the company of Mr. A. Mr. B takes this money, puts it in his own bank account. He uses multiple different channels and multiple different ways which are used for money launderers to convert this money. So this is a crime money that is there which is involved. He takes this money, might differentiate into 5 different bank accounts of 1 crore each, might withdraw some money in cash, might convert the money into gold or some form of asset. After some years, after a period of time, he may sell all of this or he may bring it back into one account. So therefore, if we see, there are 3 stages in what we've seen here. The first stage is the stealing of the 5 crore rupees, which is ideally the predicate offense that is set under the Money Laundering Act. The second stage was when this 5 crores was divided and differentiated into multiple factors, into multiple areas and multiple ways, so as to make them differentiable from the first lump sum of 5 crore rupees. This covers the exact part of the crime of money laundering, since this differentiation of 5 crores into different aspects and different assets altogether would mean that the assets, the crime money is being placed, it is being layered in different forms. And last but not the least is taking all of this 5 crore rupees, putting into one bank account and showing that this is legitimate money and it is not arisen or not come up from a crime. So therefore, even if a person is concealing money which is laundered money, or if a person is trying to showcase that yes, this money is legitimate money, those 2 steps as well come under the offense of money laundering. Now you understood what the offense of money laundering is, and we know that the punishment for money laundering is very simple technically in India, which is just 7 years. So therefore, if I look at the provisions of various laws that are already existing, be it the CRPC, be it the BNSS, or be it judgments like Arnesh Kumar, Satyendra Antil, etc., we see that 7 years is not considered a serious offense. But however, if we go into further understanding what these special laws are or what these special economic offences are, I'd like for all of you all to read this judgment of Nitin Johri, which covers section 212 of the Companies Act. Now, the Companies Act, also very similar to the Money Laundering Act, has provisions of bail, which we will come into. But Nitin Johri very simpliciter says that an economic offence is not a simpliciter offence. It is an offence which breaks the financial backbone of an entire nation, of the entire country. And hence, subsequently, and several judgments across India today say that the offence of money laundering or a white collar crime is more draconian than an offence like murder or rape or even terrorism. I understand this might not fit in well with the logic that yes, if it's worse, why only 7 years the punishment? But we got to understand one thing, is that if a person is convicted for money laundering, he is convicted for two different offences. First is the generation of the proceeds of crime. That can be of any scheduled offence, that is again explained under section 2, subsection 1 and clause Y of the Money Laundering Act. It can include the NDPS Act, that is on drugs and narcotic substances. It could include the Maharashtra Organized Crime Act. It could include simple offence like 420 under the IPC, that is of cheating, could be forgery. But the one condition is that the amount must be above rupees 1 crore, is what the Money Laundering Act states. So when the offence is above rupees 1 crore, the PMLA can be invoked. Now for invoking of the PMLA, a predicate offence is necessary. So coming back to the point of conviction, a person can be convicted, say probably for 10 years under the NDPS Act, in addition to which he may be punished for a further period of 7 years under the Money Laundering Act. So therefore, if we go to see that money laundering, though independently, is only 7 years in terms of punishment, but however, the Money Laundering Act is also intertwined and interconnected with other predicate offences. Hence, if we only see that yes, it might be an offence drawing a punishment of 7 years, we must also see that this is the second punishment that a person will be given. Now, since we've understood broadly what money laundering is, what the broad structure of the Money Laundering Act is, we see there are two different structures in this. One is the criminal part of money laundering and second is the civil liabilities. Civil liabilities amounts to attachment, wherein this 5 crore rupees in our first example of Mr. A and B will be taken from Mr. B and returned to Mr. A. If it's a government, given back to the government. If it's a bank, in terms of bank loan forgery, bank loan misappropriation amount will be given to them. So therefore we see is that the civil liability is kept at one place. Let us turn to the criminal liability. Now, as we see, money laundering is a draconian offence from what we can understand. And when it's a draconian offence, it also means that the number of people who are harmed in this are more than just one. If it's only one person, there are often scopes that yes, they might settle the matter. Say in our example, Mr. B might pay Mr. A 4.5 crores. He may say, okay, since I've received substantial amount, I might want to withdraw my case, which means that the predicate offence has come to a close. The person has been acquitted in that, and that is the reason why money laundering cannot go further. But as I take an alternate example, there is a company, a group of directors who've taken a sum of rupees 100 crores from a public sector bank. They've taken the loan, they've utilized it. Now what utilization they've done of this 100 crores is, they might have taken it for, say for example, a building project. They will invest 25 crores in the building project and the remaining 75 crores will be diverted to different companies, to their own independent bank accounts. They might purchase property, cars, luxuries for themselves. So therefore the proceeds of crime ideally in this matter would be rupees 75 crores. Now technically it is not just one bank who has been hampered, but it is a whole lot of depositors who are hampered in this case. And hence the Prevention of Money Laundering Act has gained so much of stride and has become such an important law in today's time. The criminal aspect of money laundering is divided into two very important sections. One happens to be section 19, which provides a particular officer, a designated officer under the scheme of the PMLA to have the power of arrest. Now normally if we look at BNSS or CRPC, we see that yes, if a person has a reasonable doubt that yes, a person has committed an offence, the person can be arrested by a police officer of a particular rank. But if you look at the Prevention of Money Laundering Act, it goes one step further. Section 19 clearly says that yes, there is a power to arrest, but also puts in a caveat. The caveat put in under section 19 is that the officer who is of a particular designation, be it an assistant director and upwards, as defined in section 48 of the PMLA. Second, he must have a reason to believe which has to be recorded in writing. And third and the most important condition is that he must believe that the person or the accused is guilty of the offense of money laundering. Now, if I compare it to any and all other provisions under criminal statutes in India today, this happens to be slightly different because in order to arrest a person, you must see that there is guilt of the person of the offense of money laundering alone. An officer under PMLA cannot investigate into the predicate offense to see whether, yes, has he committed the forgery, whether has he committed the cheating or no. All he's supposed to see is that, yes, there is a predicate offense today. We see that, yes, so and so money has been part of the proceeds of crime and so money has been laundered. So therefore, a very technical level of investigation is required by these revenue authorities and also by the PMLA authorities to understand as to how did the funds flow from the original source of the crime to the ultimate source, that is the entire process of laundering. Now, once the entire process takes place, they will send summons to the accused persons whom they might feel that, might either be a witness or might be an accused under section 50 of the PMLA. And when a person comes in and upon their statements recorded, etc., if they have a belief that, yes, this person might, or the person has rather, with conviction, yes, he has committed the offense of money laundering, only and only then in those circumstances can an officer under the PMLA arrest a particular accused under section 19 of the PMLA Act. Now, stopping here for a moment, are two landmark judgments that we must see over here. One is a judgment of Vijay Madan Lal Chaudhary, which is a judgment of a 3-judge bench headed by Justice Khanwilkar in the year 2022, which upholds the constitutional validity of the entire PMLA Act. The section 19, when they dissect the same, they say that yes, it is constitutionally valid for the reason being is that yes, you're giving a power to arrest. You're saying a person must be informed as to why they are being arrested. Third, reasons of why you feel that they're guilty is being recorded in writing. And hence, in their opinion, the rigors of Article 21 and Article 22 were being followed in its entirety. But however, we see that because of the simplicity of observation, Section 19 to some extent probably was being misused. And hence, in June 2024, we have the landmark judgment of Arvind Kejriwal versus the Enforcement Directorate, where the Supreme Court dissects Section 19 further and goes ahead to say that yes, you're right. Reasons to believe were recorded in writing is to be maintained with the Enforcement Directorate's officer in his file as per certain rules as well. There are rules regarding how an arrest is supposed to take place, how those documents are supposed to be forwarded to a magistrate for remand, etc., which we will come to a step further. Reasons to believe which are recorded in writing must be handed over to the said accused person, so that would help him create his defense even at the stage of remand or even at the stage of bail. Now, the reason why the Supreme Court clarifies this step further is that under the PMLA, the 3 documents that are supposed to be there. One happens to be the arrest order, which is very simplistic even in comparison to your BNSS and your CRPC. Second happens to be the grounds of arrest. Now, what are the grounds of arrest is say that yes, when you're arresting a person, there is a reason why you've arrested him. Those are recorded in the reasons to believe. Reasons to believe are the officer's reasons as to why he feels a person is guilty. That is one document. And the third document is the grounds of arrest, which says that yes, these are the grounds as to why I am arresting you. Now, there's a very nuanced difference between these 3 documents. One happens to be the arrest order or the arrest form, which is provided under the PML Act. Second is the grounds of arrest as to why a person is being arrested. And third is the reasons of belief, is as to what is the reason of the officer as to why he wants to arrest the particular accused person. So therefore, in 2024, the court says yes, reasons to believe must be provided in writing. Now, the reason why even this section 19 was dissected further is because this judgment in October 2023 by the name of Pankaj Bansal. Now, in Pankaj Bansal, very peculiar facts were there. A particular accused person was called to the Enforcement Directorate's office by way of a summon in one particular ECIR. ECIR very similar to an FIR, but not like an FIR. It's an internal document which provides the ED the power to initiate prosecution against a particular accused person. He's called under one ECIR. In that ECIR, he's already granted anticipatory bail by the court. So therefore, he knows that he has a protection against arrest. He goes to the ED office. When he arrives there, he realizes that, there is another ECIR as well against his name for another crime that he has committed or another crime that he's been accused of. Under that, he's provided summons and he's arrested immediately under the second ECIR, in which there was no protection granted to him. Therefore, the Supreme Court takes a very clear view, says that the grounds of arrest must and have to be provided in writing to the accused person. The reason for that is that at least let the accused person know as to why is he being arrested, and therefore they dissect Article 22 further, which says that when a person is being arrested or has been detained, he must be given the reasons as to why is he being detained. And that is the reason, following the cue of Article 22, is why the Supreme Court enlarges the concept under Article 19. In October 2023, they first say that yes, provide the grounds of arrest. Subsequently, in June 2024, they now say give the reasons to believe as well. Therefore, leading to full and complete disclosure around any and all arrest done by the Enforcement Directorate. Now we've understood what and how the arrest takes place. Coming to the most important stage of bail. Assume a person is being arrested, their arrest is being upheld on various grounds that can be taken. And now comes the question of bail. Now, under the Indian criminal jurisprudence, we see that every person is innocent until proven guilty. However, the slight deviation under PMLA is that he's first supposed to be, or there has to be reasons as to why is he guilty, and only then can he be arrested. So therefore, arrest under PMLA has two different conditions as to why a person is arrested and why and only when can he be granted bail. Section 45 provides for twin conditions for bail. The first condition is that the public prosecutor must be heard. As we know that the principles of audi alteram partem, any person before there is any order or judgment in his favor or against him must be heard. Therefore, following the principles of natural justice, a prosecutor must be heard as to why bail should not be granted or why bail probably should be granted. And the second condition provides is that, which is the judicial discretion of a judge or where the judicial mind gets applied, is whether the person is actually guilty of the offence or no. So therefore, under section 19 at the first stage of remand, the officer has to prove that yes, in his belief, a person is guilty. Subsequently, there is a filing of the prosecution complaint, which is similar to a charge sheet which provides the entire offence as a whole. And once this entire offence is recorded on paper and placed before the court, it is the court's jurisdiction and the duty to see whether is the person really guilty. So therefore, guilt of a person under PMLA is adjudicated at three stages. First, at the stage of his remand because of section 19. Second, the stage of his bail under section 45. And third, after the conclusion of the trial, when the court will say yes, is he or is he not guilty beyond a reasonable doubt. So therefore, bail under PMLA, if we see, is a very tricky and a slippery situation. Now, PMLA, as we know, is a very draconian law, and the history of PMLA cases in India have been very massive and extreme. For example, if we look at an offence in 2018, which happened around Nirav Modi and the Mehul Choksi scam, the very famous case of the diamond heist or the LC heist in India, as it popularly called as Nirav Modi diamonds, Gitanjali diamonds, wherein there were LCs issued by a bank outside of the entire banking system, outside of the entire core banking system, and monies were then generated, that's the generation of the proceeds of crime, and subsequently led into laundering. We've seen the case of Rana Kapoor and Yes Bank and the Vadhwans, how loans were given, how non-convertible debentures were issued in exchange of a kickback. So debentures worth X rupees were given, a percentage of that was given back to the banker, which also is a crime under the Prevention of Corruption Act. Now, because of the amounts being such massive in nature, it could be seen that the monies were not utilized for the purpose for which they were taken, and hence there was laundering that took place. All these offences in the estimations of tens of thousands of crores, hundreds of crores, and therefore we see that the judiciary in today's time has taken PMLA with a pinch of salt, saying that if PMLA is invoked, even though the threshold is just 1 crore, the people involved in that, the power, the influence, the money is of a much higher standard and level. And which is the reason, even though the offence was just 7 years, the seriousness of the same, the victimization of the same was so large that the courts were very reluctant in granting bail. Until the year 2024. In the year 2023 onwards, there was this case in Rajasthan that took place around the entire educational system, wherein there were a lot of kickbacks given, there was forgery of papers, writing of papers subsequently. Supreme Court came to a view that yes, a person has been in custody for a year and a half under the Prevention of Money Laundering Act. there are only 23 witnesses that the enforcement directorate wishes to examine during the trial. But however, even a year after filing of the prosecution complaint, the trial has not commenced. Neither is there scope of the charges being framed in the near future, within the next 1 or 2 months. And that is the reason the Supreme Court in today's time has come down very heavily upon the enforcement directorate, because what is happening is that the enforcement directorate arrests a person before June 2024 only on grounds of arrest, and before 2023 without any documentation barring an arrest order. So therefore, the Supreme Court has now said that, look, y'all are arresting people, but however, y'all are not taking them to trial. That means this act, y'all are misusing the same. Y'all are treating the power to arrest to be extremely punitive, which means you're punishing a person without giving them a fair trial, which again goes against the entire fiber of the Constitution of India. And hence the Supreme Court today says is that bail can be granted even on grounds of delay in trial. So therefore we see that under section 45 we've covered two parts. One is that when a person or when the judge feels that a person might not be guilty. Second is when there's a delay in trial. And third and most importantly are certain provisions of the PMLA Act which provide for medical bail to be granted. Now medical bail does not mean if a person is sick or infirmed you grant him bail in his entirety. Medical bail flows in two stages and two steps. The first step of medical bail is to see whether a person is being provided apt and adequate treatment while being in judicial custody, that is while being behind bars or no. If the court and the officers and including the hospitals feel that yes, he is being granted adequate medical treatment, in that case consideration for bail on medical grounds cannot be taken. However, in the event they feel that yes, treatment is of a nature which a government hospital, which the hospitals within the prison cannot provide for example, something like cancer. That treatment is very specialized. Most of the hospitals which are in the proximity of the prison or even a prison hospital may not be able to provide for apt treatment. Plus cancer as in its treatment requires a person to be in a fairly secluded, in a cleaner environment, which we know, and it's a hard but acceptable fact is might not be present in prisons today. So therefore when a person is suffering from a medical condition like this, they're often given the right to seek private treatment for a particular period of time. Now this is also enshrined under Article 21, that is their life of dignity. And there are several Supreme Court judgments right from Satyendra Jain which happened in the entire Arvind Kejriwal scam and the entire Delhi liquor policy case as well, where Supreme Court says yes, he has a right to take proper medical treatment in a private hospital of his choice, which will of course be borne at his own medical expenditure. And in addition to that, whatever procedures are provided under the Prisons Act, that will also have to be complied with. However, the catch in this situation is that medical bail is granted only for a temporary period till a person can get his ailments cured and not in a permanent stage. Medical bail might be granted for 3 months, 6 months, after which there is a reassessment of the medical condition of a person. In the event a person is deemed to be fit, he is returned back to prison, including given a provision of his medicines to take care of the national requirements, etc. For example, several cases where the Supreme Court has even, in large cases the Bombay High Court, they even granted the permission for a person to be given a cot because a person was suffering from back problem. A person to be given a particular stick, a walking stick, because they couldn't get up without support, or a wheelchair for that matter, including support of other prisoners in there, or including support of the prison guards, etc. So therefore, Supreme Court has taken a very humanized approach when it comes to this as well. However, in cases like, for example, as I gave, that is cancer, treatment might take an indefinite period of time. A person might suffer from multiple and extended comorbidities and also extended conditions which might not make him fit to be returning to the prison situation that exists. In those cases and only in exceptional situations, if the court feels a person is sick and informed to an extent that he cannot survive in jail, can medical bail as a whole be granted. When medical bail as a whole is granted, a person is said to be as good as he's on bail, which means he would have to furnish a surety, would have to submit a bond of at his own accord, or a bond of a particular relative in his case, and also go in for regular checkups. Now, some cases, the checkups can be monitored by the enforcement directorate officers or by a particular police officer. or the court also may call for regular updates after the grant of medical bail. So therefore, we've seen that under bail, there are three different situations and circumstances when bail can be granted. However, the one biggest question that I tend to put before myself is that if there is a predicate offense, if the agency in that case feels a person has not committed the same, can he still be arrested under PMLA? Now, this differentiation comes in because a predicate offense is only with respect to the generation of the proceeds of crime. A person might not be a part of the generation, but he may have aided, abetted, or assisted in laundering that generated proceeds of crime, and hence a person can be an independent accused in a PMLA offense as well. However, the Supreme Court has clarified in the judgment of Pavna Dibur that yes, a person need not be an accused in the predicate offense. However, in the event a predicate offense arrives at its conclusive end, there is three eventualities that maybe a person is discharged, a person is acquitted, or the predicate happens to be quashed. In these three situations, a person with an independent accused in money laundering will obviously gain the benefit of the same. The reason why we say he'll gain the benefit of the same is when the courts have held that there is no generation of the proceeds of crime, how can there be laundering of the same? So therefore here, in a nutshell, we've understood what the Money Laundering Act is, what the entire scheme of money laundering is, and how bail plays a role. We see that there are twin conditions provided under Section 45, but however, the tripartite test, which is also provided under the CRPC and through various judgments in the past, will also apply to an accused under the PMLA. Now this happens to be slightly self-contradictory. Why? Because PMLA arrested a person is because he is deemed guilty. But the tripartite test says a person should not tamper with the evidence, a person should not flee justice, and third is also for the purpose of investigation. However, under PMLA, technically investigation has come to an end is the reason why a person is being arrested. Hence, we see that there are 5 conditions that an accused under PMLA would have to satisfy for his bail to be granted. In addition to delay in trial, which is an Article 21 right, that is speedy justice, and second is the medical conditions for bail. Therefore, we see that bail under PMLA, though seeming to be a very difficult thing to get in because of the past history of the laws and the judgments in India, but in the present times we see that the Supreme Court has really humanized it further and upheld Article 21 to an extent which says that a person can only and only be kept behind bars if the delay in trial is because of him and himself alone. So therefore, if we see a lot of times criminal defense lawyers will try to delay it further and further by filing multiple number of applications. The Supreme Court says no, I'm sorry. If the delay is because of the court process or because of the prosecution, only and only in that situation can the delay in trial be considered under Article 21. However, if the delay is because of the accused, because of his lawyers trying to put forth the best defense at the initial stages, that will not amount to a delay in trial. And hence Article 21, though exists, is always caveated like the entire due process in India. So therefore, I think we've understood in sum as to what bails under the PMLA is. Thank you so much. I would like to thank the Hammurabi Tablet once again for giving me this opportunity. Thank you.
Ayush, thank you very much, because it was really nice hearing for such a very act which is so technical, and at the same time it has been used, sometimes misused. So both way it is working, and a nice overview you have given, maybe for a smaller thing, but obviously the PM Act is itself so big that really it was nice to hear you on the bail. So thank you very much.
Thank you.
And a small token from Hammurabi to you.
Thank you.
This for you.